Good afternoon. My name is Ronel Herman. I'm a Children's Civil Court Practitioner, legal aid South Africa at the Port Elizabeth Local Office. I'm specializing in children's court matters. These type of matters includes guardianship applications, which is dealt with in the High Courts. Also deal with divorce matters, in custody, contact disputes. In children's court, what we also deal with is children that are in need of care and protection. They are removed, foster care, and adoption. We also assist unmarried fathers who wish to have their parental responsibilities and rights confirmed. We also assist divorcees when they struggle with contact rights to their minor children. The topic that I will be discussing today is what happens to minor children when their parents pass away. Now, during this pandemic, we've heard and read about distant family members, close family members, friends, where one parent or even both parents passed away as a result of COVID, which would leave children without a guardian or homeless, or depending on their circumstances. Why this topic is also of importance is that we are approaching Wills Week during the week of 26 until the end of October. So I will just give you a guide as what to, or more information as to what happens when one parent or both parents pass away, what can be done, where they can go to. Now, we have different scenarios. Let us deal with the scenario where there is no will or testament. Now, as we know that a lot of people don't believe in wills and testaments because in some of our cultures, it's like if both parents are deceased, a family member will most of the time just jump in and take care of the children. But then, if one of those parents were employed and they report the parent's death at work or the master's office, most likely they will be advised to present proof of guardianship. Now, if there is no will, obviously no guardian would have been nominated. Now, in those instances, they are referred to our office to assist them to be appointed as a guardian. Then that person will be the appointed guardian as per the court order, which means there's no will, no nomination, but as a result of an application, and thereafter the court will confirm the appointment of that guardian. Now, what we need to look at as well is we need to differentiate between married and single parents. If, for instance, they were married to each other, both parents will have full parental responsibilities and rights. So if one parent is deceased, becomes deceased, then obviously the surviving parent has full parental responsibilities and rights. If you are not married, if you are single, whether you lived with the mother or father or not, if, for instance, we take the mother, she passes away, it does not mean automatically that the unmarried father can just come into the picture and claim that the child can now stay with him. In most instances, the family, the maternal family, most likely will dispute or refuse the father to raise the child. In most cases, they will say no, he did not acquire any of those parental responsibilities and rights. But what the father can do in a case like that is to approach the court to have his parental responsibilities and rights confirmed. So when it comes to children, there's really nothing automatic, because at the end of the day, the court needs to look at what's in the best interest of that child and what is the child's current circumstances. So when we come to a will where the parents consider the future of the children to appoint or nominate a guardian in that will, but you need to discuss that with the one you wish to nominate as guardian in the event of your death. That person must be willing and confirm with you that he will accept should you pass away before him. So in that will, you will say that you appoint this person, you give the full name, surname, the ID numbers. You can, for instance, say how you are related, my brother, sister, or friend. But my advice is, should you wish to have a will, is to approach an attorney, especially when it comes to guardianship, so that the correct wording can be set out in that will. Because the words that must be, it must be clear to the court what you wish to be done. So what must be in that word regarding the guardianship clause is that you would say, for instance, in the event of my death, and in the event that my minor son, or that my son or daughter is a minor at the time of my death, that I nominate so and so, full name and surnames and ID number, to be the guardian of the minor child. If so and so is unwilling or unable to act as guardian for whatever reason, then you nominate a second person. The second clause should set out that no guardian shall be required to furnish security to the master of the High Court or to any other legal authority for the due performance of his or her duties as a legal guardian. Now, even with that, even with the will, for instance, you draft a will, your child is, for instance, 2 years old, okay? You pass away and it's now 10 years later and you never revoked your will or set up a new one or for whatever reason. So we do not know what transpired in that nominated guardian's life by the time the parent passes away. So in most cases, it might not be in the child's best interest to have that nominated person as a guardian, but it's a good thing to have a will wherein you nominate a guardian just to give direction, who is to safeguard the best interest of that child while the child is a minor. Okay, so you as the parent make then provision to appoint a person who was at the time willing and able to safeguard the child's interests, and those interests include that while the child is a minor, that should he acquire property, you will stand as his guardian, as the third person. If that child needs a passport, if that child needs to apply for his identification document, or wish to get married before the age of 18, then that guardian, this third person, will be able to stand in for that minor child. See, so you need someone that can safeguard the interest of that child, and it's a good thing to have that. So during Wills Week that is coming, it is I would advise the public to make use of the opportunity and to seek legal assistance in the drafting of a will, and to approach people in the meantime who is prepared to act as guardians in the event of their deaths, so that while the children is under the age of 18. The guardianship clause is very important if you want someone to take care of your children when you're not there. But guardianship does not mean that your children are physically going to live with that person. You see, because you can be a guardian and then I can be the caregiver. You understand? So when I do guardianship applications for our clients, I do the one pre-relief sort will be to appoint the client as guardian and for that person to be appointed as the caregiver. Because you can have more than one guardian in different places. You see, you can be the guardian of your niece and you live in Johannesburg. Your brother or aunt that lives in PE can be the guardian as well. But then the child is maybe physically living with another cousin or aunt, but who does not, she just wants to take care of the child. But all the legalities and all those other things she wants, in most cases, they want the person that is the eldest or the one maybe with the highest education to be the guardian, and the other one that's always at home or whatever would be the one that would take physically care of that child. So when you nominate a person and you do a High Court application to confirm that nomination or appointment, you basically have to you have to include that where the child is going to live as well. You see, because if you just have guardianship, okay, I want to be guardian of so and so and so, but where is this child going to stay? You see, who's going to take care of the child's basic needs and all of that? So the two we must separate. Guardianship is one thing, and to take physically care of the child is something else. So, like I said, you can have more than one guardian, and you can act without the other guardian's permission as well. For instance, if there's an emergency and you need to have the child at the hospital, you don't have to wait for the other guardian to come and give consent at the hospital. You can give that written consent, and in the event of an operation, they can proceed or whatever. In other cases, where you need the consent of all the guardians, is passport. You see? And sometimes we have a lot of issues where the unmarried fathers or mothers can't get hold of the biological parent that disappeared or what, and then we have to file High Court applications for that. So if your children are old enough and they understand and you have that word, you need to discuss this with them. You need to say, you have this will, you are nominating Auntie so or Uncle so and so, how do they feel? Understand? Because remember, the Children's Act makes provision that the children can express their views and wishes. And if they are mature enough, they can run with that. And it is something that the courts take into account. So if they are old enough, I think the parents should discuss the guardianship clauses with them, because if, for instance, what if they say, no, we do not wish for this person to be our guardian? Maybe for some other reason, something happened. So my advice is that the parents should discuss it with the children. Obviously, the children will ask, so do I have to stay with this person? You see, and then that is what must be explained, because the people don't deal with it as if it's one thing, guardianship, and then to physically take care of that child. It's not like that. And especially with the unmarried fathers, you see, or divorced fathers, they think automatically I can just come and take my child, but the court needs to know if that would be in the child's best interest. You understand? And it might not be. And you cannot force a child to live with someone if he doesn't know this person. To understand? So it's not, to me, it's a good thing that you make provision that in future it is a person that will take care of my children in the event of my death. It's a good thing, you see, but it doesn't end there. It can go further, but we need to have that good thing first, you see, to secure, and the rest will follow. So as I said before, that the client should approach an attorney, especially during World's Week, for advice. And as we've seen with this COVID pandemic, how quickly people just passed away. And my advice is, as a result of that, we need to get our affairs in order. I hope you find this information useful. If you would like more information, you can visit your nearest legal aid office or call our toll-free legal advice line on 0800 110 110, or you can send a please call me to the following number 079 835 7179. Legal Aid will be participating in World's Week, which will be from the 26th until the 30th of October. You can visit the Law Society website and Legal Aid's website for more information on how to draft a will and to see which officers will take part during the World's Week. Our operating hours, weekdays, are from 8 a.m. until 4 p.m., Monday to Friday. Thank you.